Okay, you're Floyd Torin. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just...
Right out of the gate, this is already a serious sentencing hearing. The prosecution is basically saying this defendant could have been charged as a habitual offender, which in Texas can mean massive prison exposure. But instead, they capped the deal at 20 years. That tells you two things immediately. First, the criminal history here is extensive. And second, the defense is probably trying to avoid a sentence that could have been even worse. Question for you guys. Do repeat offenders deserve more chances? Or is there a point where the system has to prioritize public safety over rehabilitation?
Just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, wait on the way. Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just...
This is the moment the entire hearing turns. Notice how the judge shifts away from just talking about theft and focuses heavily on the evading charge. Why? Because once a police chase starts putting innocent drivers at risk, judges often stop seeing it as just another felony and start seeing it as a direct threat to the public. Crashing through fences, nearly hitting cars at intersections, that's the kind of conduct that can absolutely drive a sentence higher. And honestly, when the judge says your behavior is a danger to everybody here, you already know prison time is coming.
A danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff. Yes, sir. Good morning. Are you Carrie Altz? Yes. And will your client waive the formal reading of the indictment and the motions in each case?
Oh, yeah.
Ms. Altz, in cause number 26, DCCR 0361. Oh, hold on. Wrong number. We get 26 DCCR 0319. Getting there. You're charged with the second-degree felony offensive robbery from January 13th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet in that case some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Your Honor, just for the record, just so for the court's information, this offer in this case reflects the fact that the robbery, as it's charged, involved an assault of a loss prevention officer at HEB on the way out of the store. This wanted the court to know. I mean, the offense robbery, implies
correct.
a certain thing in one's mind. Just wanted to let you know kind of the underlying nature of the offense.
Got it. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Alts is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of a second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35024, I have a motion to revoke your community supervision. Shows that you were placed on probation January 11th of 2021 for the offense of theft of property, a state jail felony. And that was a 2-year term that was probated for 5 years. Is that correct?
Yes, sir.
And then in cause number 20-35025, I also have a motion to revoke your community supervision. This shows you were placed on probation the same date, January 11th of 2021, for theft of property with previous convictions. And that was also a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Each of these cases allege that you violated your probation. And in count 1, in each case, it alleges that you failed to report as directed to the probation department since March of 2021. Is that correct?
January. When she went on probation.
Let me look at this. I'm just trying to go back and look at the PSI real quick from the original case, if it's in here. I don't know if it's going to be there. Mm-hmm.
It might be one if it's a state jail.
Well, if it was a straight back then, I'm assuming that's because there was some criminal history. And I'm wanting to know what that criminal history is before I go along with the 21 months. Because if she went to probation for 2 months and we haven't seen her since, and she committed another offense that ended up being a robbery, then I think that 2-year sentence that she agreed to back then is probably what needs to happen on these 2 cases. I've already gone along with the other one, but I think if either of you have that information.
I don't.
As far as the criminal history, I think Judge, I've got some around here. I'm happy to share it with you and Mr. Harper.
Theft in 2013, theft in 2015, theft in 2016, another theft in 2016, theft in 2017, criminal trespass in 2017, a theft in 2018, a theft in 2019, a theft in 2021, the 2 thefts from 2021. And now we have the robbery. You guys.
If I could just say this, Judge, I mean, like the robbery, it's been, I don't know about all the thefts, but the theft, like the robbery, she took $18 for this stuff. It was feminine products and
at some time she's got to stop.
I understand about
and if someone's trying to stop you, you don't do what you did to that person by pushing them and physically.
This part is incredibly important legally. The defense tries to humanize the robbery by explaining it involved low-value items and feminine products, but the judge immediately redirects focus to the violence against the loss prevention officer. That's the key distinction. In criminal court, a theft can suddenly become a robbery the moment force or physical contact enters the picture. And now the court is looking at years of probation violations, repeated theft offenses, failed reporting, unpaid fees, and a brand new robbery case, all stacked together. At this point, the judge is basically signaling that patience has officially run out.
Assaulting them in other ways. So I just feel like we're rewarding continued bad behavior on these motions. And so really, if she wants to withdraw her pleas of true, we can have a hearing. Otherwise, punishment's up to me.
She'll agree to the 24 months, Judge. That was the original plea.
Okay. Yeah, I mean, she agreed to it already back in 2021 and then ignored us for the last 5 years and committed a new offense.
Yeah.
So with everyone's permission then, if it's agreed, I'm going to make that change on the agreed punishment recommendation sheet on each of these cases.
No objection, Judge.
No objection.
Okay, so let's go back then. Count one, Ms. Alt, in each of these cases alleges that you failed to report as directed since March of 2021 in each of the cases. Is that true or not true? True. True. Count two in each case alleges that you provided a urine sample January 27th of 21 that tested positive for methadone, which you had a prescription, and opiates. Is that true or not true? Count three in each case alleges that you failed to perform the community service hours as required. Is that true or not true? Count four in each case alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? And then count five in each case alleges, obviously, that you are behind in your court-assessed fees. Is that true or not true? Do you enter your pleas of true to counts 1 through 5 in each case freely and voluntarily? And because you actually, those violations are true. In each of those cases, I have here on the tablet documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Parker?
Yes.
And do you fully understand them as well?
Yes.
And you understand if I follow these agreements, which it's my understanding now that you have agreed to that original sentence of 24 months, is that correct?
Yes.
That you'll be waiving any right to appeal?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Is there any, no evidence, of course, that she's not competent?
No.
All right, ma'am, in each of these cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. In cause number 20-35024, find sufficient evidence to revoke your probation, and at this time, revoke your probation and sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35025, also find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. And I'm going to hand you in all 3 cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Obviously, Ms. Alt, you've got a lot going on. It sounds like there's probably drug issues. I don't know exactly what's causing all this, but you're going to have an opportunity while you're in prison to get help. They're not going to make you do it. But if you choose to do it, you can get out and you can learn how to quit stealing and quit doing what you're doing so that you can live out like the rest of us. All right. Good luck to you.
Thanks, Judge.
Thank you.